Kara Maciel and Jordan Schwartz from Conn Maciel Carey. I apologize for the delay this afternoon or this morning for many of you that are calling in from the Pacific time. We just had a couple of technical difficulties, but we will go ahead and get started, and hopefully everyone is able to log in and get started. So we are talking today about whistleblower investigations, OSHA's 11C, Title VII, and other statutes. And we'll be covering a number of different things and what you can be doing to prepare for any type of whistleblower or retaliation investigations. We're going to start by covering just generally the anti-retaliation and whistleblower protections. We'll turn to covering some statistics on retaliation charges and the claims across OSHA and Title VII. We'll then talk a little bit about reviewing the burdens of proof and review of the types of charges. We'll spend a little bit of time talking about a trending retaliation issue, which is under the Affordable Care Act. A new case has been filed and is moving forward through the discovery process, claiming interference and retaliation under ERISA Section 501. And then we'll finish with discussing how to respond to complaints and avoiding future whistleblower retaliation charges. So with that, I'm going to move right into kind of the major anti-retaliation and whistleblower protections that are governed primarily by federal law. So we have the EEOC, and they enforce a number of laws that have anti-retaliation provisions, including Title VII, which protects people on the basis of race and national origin and religion. We've got the Equal Pay Act. We've got the Americans with Disabilities Act, the Age Discrimination Act, and GINA, the Genetic Information Non-Discrimination Act. And all of these laws have an anti-retaliation provision incorporated in them, and as well as most other laws. At this point, you just sort of have to assume that you've got an anti-retaliation provision and agencies will enforce them. We're starting to see more and more people file retaliation claims under these laws, even if there's not an underlying basis for some other cause or claim. So just be mindful that it can be separate cause of action, separate claim, even if they don't have something else under that statute. And here's what Title VII's anti-retaliation provision reads. Essentially, it's an unlawful employment practice to take any adverse action against somebody because that person has opposed an action that's unlawful under Title VII, or has participated in a proceeding or an investigation under Title VII. OSHA similarly have, and before I continue, I just want to remind everybody who's on the phone to please go ahead and mute your line so that we don't get any feedback, and that would be great. Okay, so with OSHA as well obviously has a very strong whistleblower role, and they are charged with enforcing whistleblower standards under 22 different statutes, which includes the Affordable Care Act. But most significantly, OSHA is enforcing and increasingly enforcing Section 11C of the OSHA Act. And here's what that section reads. It says that OSHA, similar to Title VII, you cannot discharge or discriminate against an employee for exercising his or her rights under the OSHA Act, which includes any filing of a complaint with OSHA, or again, being involved as a witness, or in participating in an investigation because of exercising his or her rights under the OSHA Act. So it's very similar to Title VII's retaliation provision, and the burdens of proof are similar. So as I mentioned, there are some unique characteristics under OSHA, and they enforce whistleblower claims associated with the Affordable Care Act. And we're really starting to see that become a much more trending claim, where, obviously we didn't have it several years ago when the Affordable Care Act was still making its way through Congress and through the courts. But now I want all employers to be aware that there is this protection in there. And it's, again, similar to the other sections we talked about, is that you cannot discharge or otherwise discriminate against an employee because that employee has either received a tax credit or a subsidy under the Affordable Care Act, or has provided some sort of testimony and, again, participated in an investigation or somehow made a complaint with respect to the right to receive particular benefits under the Affordable Care Act, or otherwise, challenges an employer's policies or procedures with respect to the receipt of health benefits under the Affordable Care Act. So I think as ACA is starting to grow and more people become aware of their rights under the Affordable Care Act, we expect to see more people filing claims with OSHA and OSHA having to investigate under the Affordable Care Act. So as I mentioned, this is what we just talked about. Those claims also can be brought under Section 510 of ERISA, and we'll talk a little bit later about how that has presented in at least one case against a national retail chain. So with that, I'm going to turn it over to my colleague Jordan Schwartz, and he's going to talk about some recent statistics on retaliation claims.
Thank you very much, Kara, and it's nice to be speaking with all of you. As Kara said, for now, I'm just going to start talking about some statistics on retaliation claims, and then we'll go into some burden of proof and some other details about how to address these claims. First, for retaliation claims, about 10, 15 years ago, they made up less than a quarter of all claims, about 22%. Since that time, they've just been increasing exponentially. Now, not only do they make up the most significant portion of claims brought against employers through EEOC charges, they make up almost 50% of all claims brought. So sometimes you might just have a retaliation claim brought. More often, when you have a race discrimination claim or an age discrimination claim or something to that effect, an employee will almost undoubtedly throw in a retaliation claim also, and quite often that claim goes ignored by employers, and that actually is the most dangerous claim. So you just really, really need to be aware of the potential for retaliation claims or for participating in any retaliatory conduct after the potential initial underlying conduct. Similarly, whistleblower complaints under the OSHA Act, although they're not quite as high of a percentage,
we don't ever run out of minutes on our calls, do we?
They have been increasing, and right now they're about double the amount of claims that there were 10 years ago.
The conference has been muted.
One reason for that is that there's now the possibility of bringing such claims through an online system, so it's made it much easier for claimants to assert a whistleblower case. It's just, again, as with under the EOC, under the OSHA Act, you really need to be careful of these whistleblower and retaliation type claims. Interestingly, many of these whistleblower claims end up being withdrawn, dismissed, and not as surprisingly settled. But there's actually less than 1% of all these 11C whistleblower claims that actually do receive a merit determination from OSHA. So with those statistics in mind, now let's really just go through a review of how a claimant asserts some sort of claim for retaliation and what he or she needs to do to establish his or her burden of proof. Basically, all charges filed with a federal administrative body, they generally proceed in the same manner. The employee, the former employee, or the applicant files some sort of claim for the EEOC. It's called a charge. For OSHA, an employee representative can actually file a claim. And an individual files these usually at the local level. let's say the individual's in New York. It'll be for the EEOC, the regional New York office of the EEOC. And the EEOC actually allows you to start the charge process over the phone, but then you actually have to come in person or by mail to submit the charge. Whereas OSHA is a little more lax and lets employees file over the phone, by fax, online, and it actually dissuades you from coming in person. Once the complaint is filed, the EEOC or OSHA typically notifies the employer and the complainant that an investigation is undergoing, and then it asks you as the employer to basically provide your defense of what happened. It's called a position statement, and it asks you to provide facts, provide documentation, provide the law, and really, it's really your opportunity to explain the facts and circumstances of why you proceeded in the way in which you did proceed. The investigator then reviews that evidence and may conduct interviews of the parties. Recently, new law has been promulgated where now the position statement, at least in the EEOC context, is shared with the complainant. That is a departure from the previous way the EEOC went about doing things. And as for the EEOC charge, generally a plaintiff or a complainant must file it within 180 days from when the adverse or retaliatory act took place. However, there are many what's called work share states where if a state and federal law both have the same law prohibiting discrimination, it allows you to have 300 days from the day the retaliatory action took place. Then the EEOC kind of has as much time as they want to determine the outcome of whether they're going to issue a probable cause or a finding of no probable cause, and often it takes them quite a long time. However, if after 180 days an employee has not heard from the EEOC, he can file a suit directly in court. Likewise, once an employee does hear from the EEOC and receives what's called a right to sue letter, he will then have 90 days to sue directly in court. Generally, an employee must exhaust what's called this administrative process of going through the EEOC, under Title VII, before he can file a private cause of action in federal court. Whistleblower complaints actually must be filed within 30 days of the occurrence, so it's a much, much, much shorter time frame. So an employer really theoretically shouldn't have had much time to forget about what happened before they may hear about a potential claim being brought. And then the applicable guidance directs the investigator to provide a determination within 90 days of the complaint. The big difference here, though, between 11C OSHA and the EEOC is under 11C, there is no private cause of action for the employee. So the employee can't say, oh, you're taking too long to issue a determination, now I want to go directly to court. An employee actually cannot go to court and bring a claim based on a whistleblower retaliation assertion. Rather, only OSHA can decide if they want to pursue the action in federal court on behalf of the employee. David Michaels, the Assistant Secretary of Labor for OSHA, has tried to get this limitation to be removed, but so far he has been unsuccessful, and this is essentially a fact. And Kara and I, in many cases that we have, when an employee attempts to bring an 11C claim in court, we have to advise the court that it is just not proper, and it must be the case must be dismissed on that basis. notably, just a few months ago, a new Whistleblowers Investigation Manual became effective, and unfortunately for employers, it really minimizes the employee's burden to proceed with a claim. Prior to earlier this year, OSHA needed to determine whether a complainant established the elements of a prima facie case. That really means he or she almost needed to prove, not beyond a shadow of a doubt, but prove the possibility of and show the actual elements that were met to proceed with his case. Now, the only thing OSHA needs to do is determine whether there is a reasonable cause to believe that a violation has occurred. So the employee does not have to really carry their burden that they previously had to carry to show that a violation actually occurred. Now an employee only has to show that a judge could potentially find a violation. Obviously, this is a much easier standard for an employee to meet, and this is, quite frankly, a troubling development from an employer perspective and something that really needs to be monitored going forward. And the elements, as I referred to them, the prima facie elements that eventually an individual bringing a retaliation whistleblower claim under 11C, the elements needed to be proven are: 1, protected activity. An employee must establish that he engaged in some activity which is protected under a specific statute. 2, he must demonstrate that he suffered some sort of adverse action. In a minute, I'll get to exactly what an adverse action is, although for the most part, it's fairly self-explanatory. And then finally, the employee has to establish what's called a causal connection, and that he can demonstrate that the employer would not have carried out the adverse action other than for this protected activity. And as I said, to explain that a little more, examples of a protected activity are filing the discrimination charge. That's pretty basic. Complaining to an employer about workplace discrimination, or participating in an employment discrimination investigation or lawsuit. Any of those things under Title VII or the EEOC are clearly protected activity. Similarly, under 11C, making a workplace safety complaint to OSHA, possibly participating in an OSHA inspection, complaining to an employer about workplace safety concerns or issues, or participating in an OSHA enforcement action against an employer. All of those are protected activity, and the EEOC considers an employer's knowledge in determining whether there is a causal connection between this protected activity and the adverse action that I will get into next. The adverse action, basically under a famous Supreme Court case, the standard is that an employee must show that the action that was taken might have dissuaded a reasonable worker from making or supporting a charge of discrimination. So the two elements of this are, it's certainly adverse, it's actually materially adverse, and a reasonable employee or applicant would have been dissuaded from bringing this charge, and that is an objective standard. And the most obvious adverse action is firing or discharge, but there's plenty of others. There's demotion, failure to hire, failure to promote, some sort of change in duties, especially if it reduces your status in the workplace, reduction of pay, reduction of benefits, possibly a poor evaluation. Another interesting one is a negative job reference. If you leave your employer, go to a different employer, and then your former employer gives a negative job reference, that certainly could be viewed as an adverse action and retaliatory. OSHA guidance also identifies other potential adverse actions as blacklisting, harassment, making a threat, certainly treating you hostilely in a hostile work environment, intimidation, denial of overtime, and a layoff or failure to recall. And as I mentioned a few times, the word causal connection, the term really is that an employee must show that but for the protected activity, the adverse employment action would not have occurred. So he would assert that if he had not complained, he would not have been terminated. And a very typical, there's two typical defenses to this. One is employer knowledge. The employee has to show that the employer, and specifically the individual who made the decision, knew that the employee complained. If a supervisor fires an employee and didn't even know that he complained about a workplace safety issue, it's extremely unlikely that knowledge could be imputed to him that there's some sort of causal connection. Likewise, if an employee complains, let's say, again, about workplace safety, and he's terminated 3 years later, there's probably not a close enough proximity to establish a causal connection. Typically, a week, 2 weeks, maybe a month, maybe even 2 months is about the limit to what the causal connection should be. If it's anything greater than that, an employer usually has a pretty solid defense that the activity of complaining was not related to his eventual termination or other adverse action. Finally, before I turn it back over to Kara, I just want to talk about what the employer's ultimate burden here is after you get through the protected activity and the adverse action and the potential causal connection is a legitimate, non-discriminatory reason. The employee first tries to establish all the elements we've just discussed. But if the employer can show, you know what, we fired you because you were a poor performer, not because you complained. You know, look at your performance reviews for the past 5 years. We've documented that you've gotten worse or worse. Or we're firing you because we no longer have room for this job title, and unfortunately, you are just getting caught in the reduction in force. It has nothing to do with your complaint. Once an employer can establish this legitimate non-discriminatory reason, the employer should suffice to alleviate themselves of potential liability, unless the employee can then show that this legitimate reason is really essentially made up, or what's called a pretext for actual discrimination or retaliation. With that said, I'm going to turn it over to Kara to speak about some other issues.
Okay, so this next section I want to touch on is the trending retaliation issue I mentioned earlier, which is under ERISA Section 501. And what that means is, under the Affordable Care Act, if you have 50 or more full-time equivalent employees, obviously you must offer affordable health care coverage to those full-time employees. The Act requires full-time employees to be those who are working more than 30 hours or more a week, averaged over the course of the month. And if coverage is not offered in accordance with the employer mandate, then you could be subject to a tax penalty. There's been lots of discussions about how you calculate that, what your tax penalty is. Some companies saying I'm rather pay the penalty rather than offer affordable coverage. All different types of nuances that go into that calculation. But the key is in addition, is there's implications in how you communicate your decision whether to offer or not to offer coverage, or how you're offering coverage to employees under the Affordable Care Act. And this question comes up is, okay, well, did a company take action with respect to an intent to interfere with an employee's attainment of a right to which the employee may be entitled. And in this case, that would be health insurance. So a lot of questions have come out to say, well, if a company decided not to offer health benefits, or if they decided to reduce the hours of someone who was working, who otherwise was a full-time equivalent employee, down to below 30 hours a week, does that reduction of hours create an intent to interfere with their right to obtain health insurance? And if so, is that then actionable as a retaliation claim under ERISA and the Affordable Care Act? And recent case law has started to suggest that it could very well be a violation, and we're monitoring these cases, very, very closely. So the way that this case comes forward is there's a three-step burden shifting framework, a little bit similar to what Jordan was talking about earlier. Again, there's this prima facie case where you have this inference of discrimination. Either the employee or the applicant had current rights or a soon-to-be opportunity to obtain rights under a health plan. They were qualified for the position, and they didn't obtain those rights they didn't obtain the rights or health benefits, and they suffered an adverse action. Then it shifts over to the employer to have to contradict that inference of discrimination with a legitimate reason that Jordan was talking about. And ultimately, it's always the employee's burden of proof to demonstrate intent and motivation on the part of the employer with specific intent to interfere with the benefits. They don't have to prove this intent to interfere was the sole reason for the action taken, but that has to be more than incidental. It needs to have some type of specific evidence and specific intent. And so this case has recently come up in the case of Marin versus Dave & Buster's. And in this case, this is a class action lawsuit where they are saying that the managers held meetings with employees, and they said, we've decided after reviewing what our obligations are and costs and what we can do under the Affordable Care Act, we're going to go ahead and reduce employees' hours in order to avoid the prohibitive costs that the Affordable Care Act brings. And we'll also lay off employees. And so they brought a class action against Dave & Buster's saying that that violates ERISA because we had a right to obtain benefits and you've now interfered with that right. And Dave & Buster's tried to get this case dismissed. We were all looking very closely to see how the court would rule on that because the argument was that, wait a second, they didn't interfere with your right to obtain health benefits because those benefits hadn't yet accrued. It was before the Affordable Care Act came into effectiveness, and therefore Dave & Buster's had the right to reduce hours. And the court rejected that argument, at least at the motion to dismiss stage, which is the very first low burden stage. And they basically said that this is a claim that arises from the motivations of the employer, arguing that those motivations are unlawful with the specific intent to interfere with benefits that the plaintiffs may become entitled to in the future. And they holding that the critical element really is the intent of the employer, and based on the facts of the complaint, and not yet in discovery, is that at least the facts of the complaint said that there were specific intent because of these communications that management held directly with employees, showing that that was their intent. And so you want to be very cautious in how you communicate with your employees in light of this decision as to how, if you're going to change benefit levels or change hours of work or reduce people's schedules, because it could be construed as specific intent to interfere with the Affordable Care Act and bring a claim under ERISA 510. And so the highest risk of an ERISA 510 claim certainly would be those current full-time employees who are reduced to below 30 hours per week. And that's sort of the Dave & Buster's situation, is that they said even though they hadn't yet obtained the rights to the health benefits, the fact that they were currently working, they had those hours reduced. If you've got part-time employees and you cap them at 28 hours or lower, that's arguable. That is maybe a medium risk of an ERISA 510 claim. And then your lowest risk would be if you have new employees that are hired at a 24-hour cap without directly communicating to those new employees that you're doing that to avoid providing health benefits. The fact that these are new employees, you are able to effectively strategize and make sure that you can manage your hours in line with the costs and burdens associated with compliance with the Affordable Care Act. Okay, so now that you sort of know how these claims come to be, what the burdens of proof is, what do you do next if you get a charge of discrimination on your desk? What do you do next, and how do you respond to the applicable agency that's going to be investigating those claims? First of all, if the employee is still employed, if this is someone who's currently at your workplace and they're alleging retaliation because of, unfair discipline or poor performance review or something to that nature, you want to make sure that there's no further retaliation, or this employee understands that the fact that they've merely filed the charge, is a standalone protected activity, and that your company has a zero tolerance for retaliation, and the management understands that no additional or other types of retaliatory acts can be taken against this current employee. And then you want to conduct your investigation, right? So you want to look at whether the charge is timely. That's kind of what Jordan was talking about, because whether it was filed under OSHA or whether it was filed with the EEOC, there's different timing elements. And so you want to make sure that underlying the actual charge, that it's timely. You want to collect documents, interview employees, managers, supervisors, any witnesses to the issue, any non-management. You want to make sure you're interviewing employees who might have information about the allegations and the claim. And then you want to record your investigations and findings. And all of that will be helpful as you start to prepare what you're going to need to do in a position statement that you'll file with the federal agency. And the goal of the position statement, it's really important. And I work really hard with our clients on crafting an appropriate position statement, because this is your opportunity to tell your story and put you in the best possible light in front of the investigator. Up till now, it's possible that the investigator has only heard from the charging party and has only heard one side of the story. And as we all know, a lot of times those stories simply are not accurate. They're just somebody's thinking about, well, it must be because I raised a complaint of workplace safety, or it must be because of my age, or it must be because of my disability. They're not hearing kind of anything about you, your company, what you do, who this employee was, and what led to the alleged adverse action. And so it's really important that you use this as an opportunity to effectively craft your story and the story about the charging party in order to put it under the applicable framework and allow the investigator a really good and easy roadmap to follow of the facts and the law, which ultimately should reach a conclusion. Because if you give everything you can in an easy, concise format to the investigator, it's much more likely that the charge is going to be dismissed. You're going to be found to be credible, and ultimately the charge won't then go forward. And so preparing the position statement is important in light of the importance that the agency gives to them, as well as how they could be used in subsequent proceedings. So as I mentioned, you generally have different parts of the position statement. The beginning is the statement of facts, okay? This is where you're going to provide background on the parties, your type of business, the type of establishment and maybe divisions within your company. You want to directly quote from your policies and procedures that demonstrate you have an equal opportunity policy, that you have OSHA policies that advise your employees in a handbook or someplace else, that you have a zero tolerance against retaliation, that you are an equal employment opportunity employer. You want to describe the charging party, who he or she is, what the job title is, what they did on a day-to-day basis, again, giving context to the individual. And then you want to talk about the basis of the charge, talk about who was involved, who the key decision makers were. If it's a performance issue, you want to talk about the factors that led to that person's performance, the documentation and the coach and counseling that had been provided to that employee in the past. You want to clearly articulate any reasons for a discipline action or the adverse action. I mean, that's really clear, because whatever you say in this position statement, you need to stick with it throughout the pendency of this action. If it's an EEOC position statement and it happens to go into federal court, a year or two later, all of a sudden now you're at depositions, your HR team has to stick with the decision and the legitimate reason that's set forth in that position statement. Otherwise, the shifting rationales could be viewed as pretext. So that's why this position statement and the reasons are so important, that it's fully investigated from the outset and that everyone is on board with making a clear reason for why a particular action was taken. And then you're going to show that that action was lawful and explain it in a way that the investigator clearly follows and understands and believes. After you go through the facts of the position statement, then it turns to the legal analysis. And this is a lot of the times where we get involved and have other outside counsel assist in this section, because you want to be able to show that based on the facts as presented, even if everything that the employee says is true, that isn't enough to state a claim of retaliation or whistleblower under the applicable statute. So you want to look at how the agency has investigated the relevant statute in the past, maybe some court decisions, and you want to explain that in this situation, the charging party has failed to meet his or her burden, whether that's at the prima facie case or if it's ultimately at the burden to prove pretext. That in any event, this charge should be dismissed because there's no evidence of unlawful retaliation or unlawful whistleblower activity. A couple of things you'll want to lay out, as I mentioned, is that legitimate reason. As I said, that's really key, and you want to have good witness statements. You want to have good documents to support those, good evidentiary support to show that it's not just the person who's writing the statement, but it can be supported by contemporaneous documentation as well. And then you want to show that this employee can't establish that causal connection between whatever happened with the protected activity and or the adverse action. I mean, things to think about might be, well, gosh, he complained of workplace safety violation a month ago, and then 2 weeks later he engaged in insubordination, and that's what led to the termination. He engaged in something that breaks this connection between his protected activity and ultimately the reason for the adverse action or discipline. Other examples could be that the activity itself was not protected by applicable law. I mean, we've got, Jordan and I have defended these cases a lot where somebody, brings up in a particular manner, that they think they're being treated unfairly, but they don't explain what that means. And then we get a charge for retaliation. And what we explain is, look, they have to be opposing some unlawful practice under Title VII or ADA or age discrimination. And just saying that it's unfair isn't enough to be protected activity. And so there's a lot of different ways that you can show those facts and support it by the law, which again gives the investigator everything that they need to dismiss the case and not have it proceed. So I talked about the importance of supporting documentation, and I maintain that. I mean, this is where your investigation is going to be important. You're collecting documents that are in someone's personnel file. You're collecting documents from decision makers. You're looking at your handbook policies and procedures to make sure you have everything you need to tell your story, again, and lends credibility to what you have to say in the position statement. And up till now, I would say up to about a month or two ago, I had no qualms about submitting that documentation to the EEOC because I knew that it was held confidential and the charging party would not see it. And if we ever got to court a year or two later, I understood that it could be subject to a FOIA request or would be made available in discovery. But at least in the EEOC process, I understood that to be confidential. The EEOC has now changed its decision, and Jordan alluded to this earlier, and now says that it will release everything that's submitted in the position statement, including any non-confidential attachments to the charging party upon request. And so be very mindful going forward now about the types of documents that you want to attach to a position statement. You can certainly designate them confidential, and if they are properly confidential because they contain some kind of proprietary information, trade secret information, other, again, confidential information about the company or the employee or third parties, we could redact those or we could make them confidential. But in this age of social media, I'm very, very leery about getting information in the hands of a charging party during an investigation because they could use that information to influence the investigation one way or the other, or make the documentation available up on social media, blog about it, all different things that can happen on the internet. And so you want to be, again, very careful when you're crafting these position statements that every single statement is true, that every statement is supported by facts, and that, you know, the documentation that you're attaching doesn't have extraneous or other information that you would not want disclosed if it happens to get out to the charging party. So then, as I mentioned, you know, this is what the EEOC recently has said, and then OSHA has a similar position, and they say essentially in their the new Whistleblower Manual that investigators, in their discretion, can provide a summary of the employer's response instead of the actual response, but generally that summary should only be provided if providing the actual documents are not, would be inadvisable. And OSHA developed that exception to address issues that could lead to an incident of workplace violence. And so, you know, based on our experience, we think its applicability is pretty limited and often, you know, probably won't be used. So regardless of which agency you're providing your position statement to, I mean, I think you can guarantee that probably part of it, if not all of it, will be disclosed to the opposing party, and it's something you want to take into consideration when you're drafting it. So now that you know how to respond to position statements, ultimately, how are we going to avoid whistleblower and retaliation charges? That's the most important thing, so we don't have to spend, you know, time and business and witnesses and legal counsel on trying to defend them. And the most important way that you can protect yourself against retaliation is to train your managers and supervisors. You can have the best policy in the book, terrific handbook, everybody reads it on the first day of employment, and then they don't look at it again. If you have managers that are somehow taking actions that could be viewed as retaliatory, as Jordan mentioned earlier, they need to understand the consequences of that, and they need to understand what could happen as a result. And so when Jordan and I do our trainings for employers on, you know, preventing harassment and discrimination in the workplace, a huge part of that training, in addition for managers and supervisors, is preventing retaliation, so that they understand that it's not just, you know, hiring and firing and, you know, those things in terms of clear employment actions, but the subtleties of retaliation. You know, it's the, you know, not giving people good work assignments, or not approving people's scheduling or vacation requests, or denying a telework arrangement when, you know, other people are allowed to have it. So there's a lot right now of real subtle retaliatory actions that could take place, and managers are really need to be trained and understand how that could come up in the workplace. So management needs to be trained on, you know, how to respond to complaints, how to escalate that to HR, how to, you know, how the company handles those types of complaints, the types of actions that are considered adverse, the perception of retaliation. You know, someone engages in activity and then all of a sudden they feel like anything that happens when they come back to work or after they report a condition, anything that's going to happen could be viewed as retaliatory. And then always, you know, the importance of effectively communicating why you're taking actions, the reason that you are. If you can't approve someone's vacation request because everyone else, other people in the department, you know, are out as well, and you've got business needs, communicating that to the employee goes a long way in avoiding any misperception that they're being treated unfairly or somehow retaliatory. And then always documenting that legitimate response, you know, in the documentation. That's if there's a charge filed later on, you're going to want to go back to that documentation that the management completed at the time that it happened, again, to support the legitimate response and use it as a document attached to your position statement. So, you know, as important as training is, you know, document is equally as important. And I know, you know, in HR and some managers, they don't like to document. They don't like to provide constructive criticism, and they certainly don't like to document. And a lot of times, if someone says, a manager says, well, I think so-and-so needs to be fired, you know, HR comes back and says, well, wait a second, where, you know, let me see the documentation. Let me see why this person's a poor performer. And sometimes it's not there. It's not in the file. And that's why it's so important that every step of the way you are documenting this situation that employees are doing so that you can use that to support an adverse employment action. You know, maintaining clear written documentation for all disciplinary actions is important. You want to detail the decision-making process in order to make sure that you're following your non-discriminatory company policies and procedures. And to the extent you've got training on these policies and procedures, and you can show that someone, attended, a workplace safety training, and they know how to handle certain materials, and they know how to follow certain procedures, and then they didn't follow your procedures, you can show that they've been trained on them, they were aware of your policies and procedures, and they didn't act accordingly, and keep that as documentation. And then you want to, conduct investigation and document the process of any complaints of discrimination and retaliation. And that's also very important by keeping notes of employees' interviews, reasons for why you came to the conclusion of the investigation and why you didn't, any follow-up actions that may be necessary to take place after the investigation is concluded, and then keeping the complaining party apprised of the status of the investigation and ultimately the resolution is very important. Sometimes people feel like if they're not kept informed or they don't know about how a particular investigation was concluded that they brought, then employer must not have been doing what they needed to be doing. And so again, communicating and providing all of those legitimate reasons to the complaining party can go a long way in avoiding a charge being filed in the first place. And then with respect to ERISA 510 claims, it's important as you are looking at how your company is responding to the Affordable Care Act, and if you are making any changes to hours of work and scheduling because of an overall benefit strategy, it's really important that you keep ERISA 510 in the back of your mind and manage any communications to avoid a specific intent argument, right? So you don't want to make any public statements. Don't issue a press release, don't go on the news, don't talk about why you're doing, the things that you're doing. To the extent you're having workplace meetings or, town hall meetings or all employee meetings, you want to make sure that you're communicating that message in light of a legitimate business need and not in response to new regulatory requirements. Consider avoiding capping or cutting employee hours if you can. You want to make sure you're protecting decision-making documents, any notes, anything where this is talked about, protect that under privilege if you can, so it can't be produced, and really centralize those communications through one voice and making sure that that is a strategy that's implemented across the company so that you don't have different people saying different things that ultimately could be used against you. Consider grandfathering current 30-hour employees. And then look at your employment agreements to reflect employee status going forward. If you hire, ongoing part-time or new hires, if you're going to limit their hours of work below the 30 hours in light of the Affordable Care Act. Hopefully, by taking these steps and the steps we talked about earlier, you can avoid falling into a trap that Dave & Buster's did. So I know we're just reaching about an hour, and I know we started late, but this is being recorded, and the slides will be made available. But if anybody has any questions, certainly feel free to add them into the chat box on the webinar, and Jordan and I are here, and we can keep the lines open for a while to answer some questions. And you can always reach us after if you can't think of any questions now or something pops up later. Don't hesitate to reach out to either Jordan or myself, and our contact information is on the screen, and we'd be happy to answer your questions. Well, we always appreciate everyone's attendance, and again, thank you again for sticking with us with our technical difficulties earlier. But this is, part of the OSHA webinar series, and there'll be several webinars throughout the remainder of 2016, and we hope that you are able to join on to those webinars in the future. I hope you found this one helpful, and you learned a couple of things that you didn't know about before. And if you have questions, as I said, don't hesitate to reach out to us or to Eric Conn, and we'll be here to help. Thank you, everybody.